So Roy, why don't you get us started?
Okay. I may even be able to do this in less than 10 minutes. Um, the I'm relatively a newcomer to the GVC context, and I read a bunch of work and felt very much enriched by it. Um, and in a lot of ways, uh, my feeling about it was that uh, it illuminated for me um, a lot of things that were, I don't know if wrong is the right word, but wrong about contract theory in general, about the assumptions of contract theory as we normally experience it, um, and the and that felt like uh, a productive thing for me in the sense that, um, like a lot of legal theory generally, contract theory um, is typically done in a very constructive normative mode. Everybody wants to make the world better, and who wouldn't, of course. But I'm I never managed to identify with that. It's not that I don't want the world to be better. I, of course, would like the world to be better, um, but I never identify with it in terms of uh, not never. I often don't identify with it uh, in terms of thinking and in terms of optimism about contract. Um, so one of the things that I uh, took from the GVC literature was really about something that looks on its face like it's about specificity, like it's just about this special area where these contracts are very complex and they're doing all this governance work and people are using contracts to really control lots of other parties. And the more I read into this, the more I thought, well, this is actually the general model. This is not special. This is how contract works, not how contract as a pure concept has to work, but how contract has worked since certainly late in the 19th century, if not before that. And one of the things I thought again uh, in the wake of this was that all contracts are in restraint of trade. So the idea behind a contract in many instances is to make a little barrier around one one particular trade in order that lots of other trades don't occur. Um, and the the way I try to articulate that in the paper is by looking at what I think is the best developed historical work on the issue that didn't come from a legal scholar, but from Thorsten Veblen, who's an economist who I think had the wherewithal in real time um, to think most deeply about what corporate capitalism was really about. And uh, so so one story about how capitalism works is that once upon a time we had a sort of very austere and strict individualistic system of private law. And somewhere late in the 19th century, when things began to get complicated, there was a lot of pressure for socialization of private law, meaning taking into account the the bad social results of having an individualistic law. And Hayek articulates this in the mid 20th century in the starkest terms. He says, once upon a time we had general rules that allowed individuals to be free, and yes, that created uh, inequality of sorts. Equality before the law meant inequality of results. And since the late 19th century, all kinds of attempts to bring private law into alignment with social goals, or what he calls the shimmer of social justice, have eroded that sense of private right, and their policies geared toward is improving the bargaining position of weaker parties, and so on and so forth. And what they actually lead to is a kind of they are the road to serfdom. They lead to a kind of totalitarian social engineering that is destructive of private rights. So forgetting Hayek's particular normative take on this, the story that there was once upon a time this sort of harsh individualistic system, and then subjected to socialization, meaning looking out for the results for the weak, is a very common story, and some people lament it, and some people obviously celebrate it. And I think one of the things that happens in GVC literature is an attempt to say, yes, look, we did socialization in a pretty good way and with pretty good results for national systems in the global north. And now we really have to look at that model to try to replicate some of those gains in the GVC context, which is different in the sense that it's transnational. The units aren't exactly the same units. The methods of control aren't the same methods of control, but the way to approach the problem is to actually replicate the kinds of gains that we made by socializing private law. And my take on this is that that isn't really the best historical view of the way the law developed. And instead, one of the major things that we did was we made law safe for profit-seeking aggregations, meaning basically corporations, but they could be trusts, they could be almost anything else. And the ways that we do this are mostly through private law mechanisms that allow parties to engross, right, to rope off the benefits of knowledge, so intangible property, branding, and so on, and make those things the basis of valuation. So Veblen's analysis that's in the paper, or an account of it is in the paper, talks a lot about how the corporation actually is mostly its intellectual property. I read this and I thought, wow, he was writing about late 19th century corporations, but it's doubly, triply, 100 times true for the kind of branding that is what GVCs are about. And so my take, in a way, ends there with thinking that actually our narrative about what happened should be completely different. We should see this as an intensification. We should see that where we are now is an intensification of the kinds of things that happened in the 19th century. We should see the socialization as really an empowering move for corporations rather than the other way around, and one that, because it allows them to engross the benefits of intellectual property, it actually leads to higher and higher concentration. And so the kinds of things that we're thinking about sort of expanding private law into the regulatory space should take those dynamics into account. And I'll end there.
Okay, thank you, Roy. So I think we lost Jaako in the wilderness of Sweden. No, he's back. Hi.
Hi, sorry, I was wondering, my internet connection seemed a bit unstable, so I was wondering whether I could do something about it, like open the door to where the kids are playing.
You can push it.
Are you actually on the outside, or it's just a picture?
I don't know, some kind of mountainous area, wilderness.
Okay. I'm impressed. Yeah. Go
Run
ahead.
to the hills. Yeah. Thank you, Roy. I very much enjoyed the paper. I very much enjoyed your comments here. And I have a few slides. I wonder if I should take them up or I should not take them up right now.
Yeah,
If
yeah.
the idea was that we should have our presentations
No,
first and then the conversation.
You do your presentation and then we'll have the conversation.
But
Okay.
it's a bit difficult because the conversation sort of intertwines with the presentation and so on. So
Oh,
it's
it's
difficult
okay,
to
but we
separate these
don't
from.
have to draw strict boundaries. It's okay.
Good.
Doing
Okay.
this Australian
Wonderful.
style, not Swedish style. So, you know, it's
Oh,
more
just a
fluid.
second. I'll try to get this started. Share presentation. So, my name is Jaako Salminen. I'm from Lund University in Sweden, the Faculty of Law. I try to do traditional Nordic private law, contracts, torts, that kind of stuff. And then occasionally I dabble with global value chain theory, wondering what global value chains are. Roy raised some very interesting points about Hayek, for example, general rules that allow individuals to be free, talking about our understanding of how the capitalist economy works. And sort of the starting point for my paper was this sort of simple thought that if we can know all the global consequences of our transactions, should we be held responsible for these consequences? And this sort of takes it beyond the GVC frame, I assume, to a sort of a more profound. I'm not sure if it's more profound in any way, but sort of thinking about the interconnections between all private actors in the world. And I'm not sure if the GVC frame is the best one for this, in part because of Roy's very well-founded critique in the paper he has here and what he presented here. I'll get back to that a bit later. But then again, it has perhaps helped us then outline this thing that's happening in the world and to sort of give some kind of a meat around this. One of the things that I've been starting with is the quantification of, well, our world system, whatever we want to call it, how the world works from an ecological or social perspective. We have the Rockströmian planetary boundaries model. I sort of assume that everyone has heard of these. It's some kind of a scientific, or some might call it a pseudoscientific quantification of where the limits of growth go on our planetary system, for example, in relation to CO2 emissions or acidification of oceans or biodiversity loss. So, but the basic idea is that we have some kind of a global science going on that tries to create increasingly strict metrics on where the tipping points go. They don't take any kind of bearing on the social aspects like freedoms, private freedoms, or what is a life worth living, which is a problem. And then we have other actors like Kate Raworth, who's tried to integrate some idea of social boundaries or societal boundaries models, taking into account a good life in some ways, or some kind of an idea of a good human life, nice work or decent work, decent labor conditions, and so on, and then try to embed this in the Rockströmian model on ecological boundaries. We have the United Nations Sustainable Development Goals that sort of try to do the same thing. And we have this creeping quantification of the SDGs also. We have the SDG tracker. So we have this underlying increase in scientific knowledge on what constitutes one perspective of a functioning world system, ecological world system, and then on the other, this much more debatable and fluid idea of what would constitute a nice life for laborers in Bangladesh and so on. But then again, that is also, I mean, well, I leave that to the labor lawyers, but I think that's also quite well set in what would be some kind of a basic criteria for this. So that's one thing, this quantification or metrification or whatever you want to call it of the whole world system, both the world system without humans and then this social part of humans within this world system. And then we have this developments in governance stemming a lot from, well, value chains, corporate groups, supply chain management. We have extremely advanced supply chain management systems, which have been the foundation of the GVC mode of production by ensuring, for example, their logistical functionality. If we have production taking place between 12,000 suppliers in 70 different countries, sort of a simple example, then of course the logistical arrangements between these holes are extremely complex. Once you then learn to work on the logistical things, then you start thinking about efficiency. We have lots of research on increasing cost management between thousands of independent actors in dozens of different countries, typically by lead firm. And then, of course, if we start thinking about cost management, we start thinking about research and development capabilities, thinking about resilience in case of crisis. We start eventually thinking about even sustainability issues. And this then depends a lot on what the lead firm has for interests. If we now, for the moment being at least, stick to the GVC lead firm frame of reference, which I kind of want to avoid, because then the next question is, if we look at governance, these definitions of a value chain, and that's something that I would hope to see well defined in all papers from now on, because quite often we just look at a part of a supply chain and claim that that is a value chain perspective. But if we go to Jereffi's definition, for example, from 2014 or even earlier, a value chain is a very all-encompassing term that tries to then subsume all processes related to production. So we don't really need to phone a lead firm. We can think about consumers, for example, or the role of private individuals, the users. It's much more than just the one firm and its supply chain. It encompasses the production phase, the supply phase, the use phase. And we have these wonderful examples coming out from America right now where, I don't know, General Motors gets all this data from users' cars, how fast they are braking, how poorly they are braking, what kind of traffic accidents they contribute to. And then they're getting this real-time data and selling it to insurance companies, and then suddenly private individuals don't get car insurance anymore, except for the state-based fallback options. And end of use, of course. So a value chain is a very all-encompassing concept, at least from a theoretical perspective. So from this perspective, it feels it would well fit in with this all-encompassing world system perspective also. And then if we go a bit to the future, we have digitalization going on. Material flows are being digitalized through tokenization. We can have AI models trading on the commodities in real time that are sort of creating the foundation of the value chains. We don't need to fall back into these classical models where a piece of paper or the good itself represents itself. We can have digital tokens doing this thing, but that's a bit more into the future. Anyway, we have extremely advanced supply chain management systems, and these systems are increasingly available also to private individuals, corporations. They take part not only about the supply chain, but also govern users, so on. And then we start thinking about what the repercussions would be for law. Well, we have the UNGPs, for example, where there's some kind of an elaboration of responsibility to respect human rights by avoiding causing or contributing to human rights impacts. And this would then apply to all companies, and they try to elaborate in the UNGPs on what this idea of mandatory, well, not mandatory, but human rights due diligence that they used in there would in practice entail. And it depends, according to the UNGPs, on the capabilities of different kinds of corporations, whether you're a big corporation that has full oversight over everything, users, supply chains, or whether you're a small enterprise that has much more of a limited perspective, probably. And the third pillar of the UNGPs then requires or sort of proposes that states should guarantee effective judicial remedies. They also talk about non-judicial remedies, other remedies there. But what I find most interesting is that states are supposed to guarantee effective judicial remedies for adverse human rights impacts that companies have not been able to avoid. You have the OECD guidelines for multinational enterprises, which say pretty much the same thing. They have some niceties, but let's not go in there. At least now we have then we have the political impasse of the zero draft on the business and human rights, and the political impasse of the Paris Accord, the WTO, the World Health Organization right now, which are really pushing nation states or regional actors to sort of try to secure their interests from their own policy perspectives. Don't really want to go into that in detail right now either, but well, or the debate about where we'll end up with these European instruments that are now being watered down, even though they were very much watered down already last year when they passed, like the Corporate Sustainability Due Diligence Directive, the Carbon Border Adjustment Mechanism, and so on. Let's just say that there are many of these instruments on national level in Europe, in other countries outside Europe. Also in Europe, there are many more in Europe, in the European Union, outside the impending omnibus discussions also. So I don't really see a problem in the political climate in that sense, but that's a wholly different idea. But the basic idea that I just wanted to highlight here is that, for example, the CSDD is very much built on the UNGP model. Companies are expected to exert some kind of a governance, and then they are held liable for damage that they cause or contribute to if they don't do this governance in general. So there is this quantification of the world system. There is this increasing understanding of what we can control, what companies can control through their supply chain management governance systems. And we have these legal debates that are very sort of far-reaching in theory, but in practice, we're trying to figure out where they lie in the global political economy. And the question that I sort of wanted to pose in this paper is then, how does this go together with tort law? So forget contracts for a while and think about tort law. And well, unfortunately, I wrote the paper a week after the deadline, so I didn't send it to you yet. And I'm still working on many of these things. But one of the basic foundational ideas of tort law is, of course, that damage caused must be remedied. But then again, we can debate what is damage caused. We can talk about different justifications for any kind of tort law principles, from wealth or welfare maximization to corrective justice, which is, I guess, what I'm most banking on, to commutative distributive justice prevention. I'd really want to have a more detailed discussion there, but I think we have to leave that out for now. Then, of course, the parameters, the practical legal parameters of tort law, duties, breaches, faults, causations, these kinds of things break up any idea of damage that is caused having to be remedied in practice in many ways. But if I sort of try to highlight what I'm trying to do here, is we had a Danish scholar who's very sort of established in the Nordic countries writing in the late 1800s, Henry Ussing, who basically proposed in 1914 that all inherently dangerous activities must be accompanied by strictish liability. And I'm strictish, well. And the question then arises, what is an inherently dangerous activity? What the legislators in the Nordic countries have been doing, and I suppose this resonates in all other legal systems also, is to establish categories of dangerous activities through legislation. And we can talk about traffic accidents, environmental damage, employer's liability, product liability. What's important here is that courts have considerable freedom. Well, not considerable freedom, that's again a debatable term, but have a freedom to expand this strictish liability to other areas. And classic cases in the Nordic countries include, for example, an oil company being held liable to damage to third parties for damage caused by a gas station franchisee, or an employer, a construction employer, being liable to third parties for damage caused by a subcontractor while digging and breaking, for example, data mains, data couplings, and so on. So the question then becomes, if we know everything that we know from the planetary boundaries model, the social boundaries model, and so on, if we know all that we know about what companies can in practice do to govern their value chains, from our advances in supply chain management technologies and so on, our ideas of what a global value chain is, what parts of it can be governed in different ways, should we, in some situations, classify outsourcing as inherently dangerous? The problem here is that outsourcing has been some kind of a global norm since at least the 1990s. We can't really conceptualize a world where, well, like Roy said, that corporations are mostly their intellectual property. So if someone has this intellectual property, then they, of course, outsource everything else, except perhaps ownership of the intellectual property, to other actors. And this has become the modus operandi of at least, well, a vast majority of Nordic corporations. So what can we do about outsourcing in these kinds of situations? We can think about classifying some kinds of outsourcing as inherently dangerous, from the global north to the global south, for example, or then we could return to a more case-by-case, fault-focused analysis. I've probably spoken for too long now. The Begum versus Marin case is something that I like to talk about, but we can perhaps return to that. I can't see my time right here. I get the feeling that I should stop soon, but do
Yeah, you
let me
should
know.
stop soon, but it's okay. I mean, if you want to
Okay.
take an extra 2 minutes, that's fine.
So I guess what I'm trying to say is that we have these foundations in tort law to hold people liable, hold actors liable for how they outsource things. We don't have that much practice, and the problem is, of course, that the practice is that everything except fundamental ownership of IP, and even that in some situations is probably outsourced. And if we would then start thinking about some kind of a convergence of law where this kind of liability exists, we would probably end up in a kind of situation like the US arms industry, or what we see happening in many different situations is that we have, well, companies contributing to adverse impacts. The Sandy Hook case is a very sort of classic example by now. And what do legislatures do in these kinds of situations? They try to protect their constituencies. We had the Protection of Lawful Commerce in Arms Act in 2005, which tried to inhibit these kinds of claims. And it took something like Sandy Hook to then even try to think about going beyond the protective legislations to force this tipping point that when we know that the gun maker is promoting the sales of a weapon that appeals to troubled men, only in these kinds of extremely crazy situations, then we can think about tipping the scales. And I guess that's sort of what's happening to some extent also in Europe. We had these developments with these value chain related regulations. Now we have this big debate in the pressure, facing pressure from the Trump administration, facing pressure from the Chinese administration to then sort of think about protecting our interests and focusing value chain governance in local policy safeguards like conflict minerals instead of global sustainability. So this is something that no doubt needs to be taken into account. But that said, I sort of feel that, and now I have the wrong slide here. It says a governance theory of contract. What I'm trying to argue for is more like this, I would want to say Hayekian perspective of freedom, but reciprocal freedom in the sense that if I, for example, know that acting in some way causes distress in other parts of the world, then is that really something that I should be allowed to do as a private individual? Or is that within the limits of my freedom to keep on driving a car that spews emissions that causes global warming? So I would really like to take it beyond the GVC frame. And this is where I come back to Roy's wonderful paper, starting with the first footnote, of course, which is we. Who are we and what are we doing? But then on page 3, you start talking about global trade. And I would love to think about us on a more fundamental level than through capitalism. But maybe I'll just stop here and then engage with the debate later, because I sort of see global value chain theory. The problem there, of course, is that it has its moment of origin, I don't know, in development studies. It has its moment of origin in Williamson's theories of corporate governance and extending those to contractual situations based on, for example, McNeil's theories of contract. So it has this very irritating origin story, but the basic fundamental idea of drawing connections between all the individuals in the world to one another, whether it then happens through elite firms, which seem to hold much more power right now than private individuals or states, that's an open question. But that's sort of the fundamental thing that I also would want to see GVC theory as reflecting, or as using it as a technique for creating this global map that connects individuals, not just companies and their supply chains. And I think we should have the techniques right now to do that from some kind of a technological perspective.
Let's open it up for a sec. I think one question is, are we talking about GVC theory? Are we talking about contract theory? Which would be I think, two different things. And I would first like the two of you, if you can, I mean, both of you give a big, kind of a bird's eye view of contract law and what happened to contract theory and what happened to contract law and how do we want to rethink it. And I'd like, if possible, if you can accentuate where you come together and where you are separate. And you're talking about the debate, what is the debate? If you can kind of spell it out. And maybe Roy, you'll start and then we'll move to Jaako and you kind of then keep both of your mics open and take it from there.
Okay, so um, all right, I don't know what the right level of generality is to pitch this, but I'll say the following thing. So I think there's a long-standing debate. It's a sort of trope within contract theory about how much contractual fairness do we want to impose in some regulatory mode on contract. Um, and sort of the socialization narrative that I talked about assumes that once upon a time we didn't impose very much fairness, and over time we imposed lots more fairness. Um, I'm not crazy about that narrative, but what I would say is that when we look for contractual fairness, um, I think we have a tendency to run together two kinds of fairness that we might be interested in. So what contract has been, I think, very successful at in the last 150 years is articulating the kind of contractual fairness between parties to a contract that it requires of those parties, meaning policing the behavior of the parties within a contract once they're in the contract. And policing that behavior just means basically making sure that they don't exploit opportunistically the vulnerability of the other party within the contract, and within the contract basically because of its temporal assignment of the obligations. So one party who's incredibly strong in the outside world becomes vulnerable to the other party who's weak in the outside world within the contractual situation simply by having performed first and waiting for payment. If the second party who's weak in the outside world can somehow opportunistically withhold payment, there's an issue of fairness among those two parties. That kind of thing has been policed well by contract. It was policed always in contract, but its articulation has become uh, better developed. The other kind of fairness is trying to actually police the market. That is to, uh, you know, sort of level the playing field between weak and strong parties before the weak and strong in the outside world, weak and strong in terms of how they come to the possible relation among them. And their contract has done, relatively decent things in terms of the process of contracting, and has basically been hands off about actually policing the market. So if the parties through a process uh, that was considered fair, if it can somehow be attributed to the fact that they knew what they were getting into and weren't fooled by anything, then contract will not intervene in the fact that the contract is actually an expression of their unequal position outside in the outside world. And the exceptions are that it can take certain things off the table, uh, usually not inherently through contract, but through the regulations surrounding contract. For instance, minimum wage does that. It takes off the table the possibility of contracting uh, for less than the minimum wage, at least if you want an enforceable contract. That is, I think, for people who are interested in problems that are of market structure rather than of contractual performance, an important thing to remember. And then it means that contractual fairness for the context that we're dealing with here is a weak, um, I think, is a weak formulation of what we're after. Because what contract knows how to do in terms of contractual fairness is a very, very small part of what we might consider problematic. Um, and I think that extends. I don't know So I have something to say about accountability and liability and what it means for the orientation of the parties, but maybe that's a different issue. And so I'll leave that aside for now.
Jaako.
Um, yeah. Well, I the there are so many things coming to my mind. I'm trying to figure out where to start. Just, I mean, thinking about the market, problematizing the market. One of the big problems that I feel we have is that our ideas of markets are very much restricted. We have a very different kind of a regulation in the European market vis-a-vis the Swedish market, vis-a-vis then the whatever would be the transnational or global market. And we often think about fairness in terms of some kind of a abstract idea of markets. And sort of the thing that I feel that GVC theory helps is then to transcend these previous ideas of markets. And this is a debate that's also going on then in competition law, at least in the European sphere, very much like I heard Klaus towards the end of the previous presentation referring to the were they commission guidelines or what were they? And there's been an ongoing debate on how to then should we reconfigure ideas of market within within European competition law to think about also effects outside the European market, which is something that many of the sustainability regulations focus on. And every time we start talking about markets, we end up in these debates about what kind of regulatory, legislative earmarks we should have, for example, on environmental legislation or consumer safety or things like this. And these are very fragmented, these ideals for now, even though what I would then hope to see happening is that we would reach some kind of a consensus on what would be a global underpinnings of a global market, a world market. And towards this, I would see that the Rockstromian model is one of the first sort of inclinations, maybe then the ILO treaties and so on. From a labor perspective, there are so many problems to conceptualizing a global market, but this is something that should be then taken into account if we start talking about regulating the market. I feel a bit hopeless regarding that. It's a very idealistic perspective, and therefore I guess I'm focusing then on what this might mean from a tort perspective instead, which sort of gives us perhaps somewhat more flexibility to override concepts of market. The problem there, of course, is that tort is also very much dependent on remedial institutions, and we don't really have functional remedial, functional transnational or functional global remedial institutions, despite what the UNGPs then try to force states into putting in place. There's always some kind of a possibility to raise a claim for damages, but there are so many hindrances there that we can say that the same problem, just phrased in another way, applies also to tort causes of action. What then would be the relationship of contract and tort in these debates is yet another question. I was fascinated by well, I don't know. I would like to take a sort of a more historical perspective also into how the world has been regulated through ideas of contracts before the industrialization and so on. But maybe that goes way too long here. There was at some point, because when I was reading your paper, I was thinking about your reflections on well, capitalism. And I didn't have time to go into that, but we have had some kind of a contractual regulation of some kind of a market before we came up with terms such as capitalism. So I was wondering how that would bear them there. And I'm thinking about markets in general. You were also referring to Amy Cohen's work, and that brought into my mind her paper on alternative dispute resolution and anti-imperialism. And I sort of feel, well, maybe she was younger than, I suppose, 10 years younger, and I sort of feel that I'm still also young and naive here. But one of the ideas of this SDG model then would be to sort of use GVCs to implement some kind of a global model for stakeholder anarchy instead of relying on these existing concepts of markets that are very fault prone right now. or concepts of contract. And that's sort of something that I also read into contract theorists such as Ian McNeill. If we start talking about relational contract theory, if we start going deeper into his work, then it becomes something very different from the model of contract that, for example, the Trump administration or even the EU Commission is trying to establish. It becomes a discussion, it becomes mediation. For Ian McNeill, relational contract law, I mean, you forget about arbitration, you forget about courts, you have people sit down, talk about their interests on a broad scale. And this is also then what I read into the early work of Amy Cohen in relation to dispute resolution as a form of perfect, well, it has its faults, but some kind of a stakeholder anarchy. And I guess that would be the utopia. And I see that we would have the workings of this utopia. The question then becomes, do we have any way of moving the legal system in this fragmented world towards these kinds of utopias? And I probably fail there, because then I start thinking about these old Danish utopists in writing and contract and tort in the early 1900s, just on the eve of the First World War, and thinking about how to reframe contract. But contract is very malleable. If we think about contract doctrine, I mean, it changes in relation to times. One of my favorite contract manuals in the US is Corbyn on Contracts, but the post-war versions, where he still talks about contract as giving us the tools of appropriate deciding on whether to sort of, even if we have a contract with a hotel for supplying coal, for example, but there's a hospital that's in more need, then Corbyn basically says that, well, looking at the American contract doctrine, we can just not care about the hotel and reallocate the scarce coal resources to the hospital because of, well, what we've been seeing happening in the Second World War and so on. So at some level, I would feel that there's lots of maneuvering room for these kinds of contractual doctrinal discussions. Whether they, again, are politically reasonable goes to be seen. But then we had the very same discussions in relation to vaccines, for example, during the COVID pandemic. They didn't work that well, but these ideas are very much ingrained also in our times today. So I really...
So maybe we'll stop. This would be a good place here, maybe, to get some more people in. I think there are two levels here. One is, what are the utopias that we're thinking about, and what are the ways to get there? So the question is whether the utopias are presented here one and the same, and whether the instruments are different. I think that there are a few levels here, but let's get some reactions here, and then we can take it from there.
EC has his hand up.
Easy.
Okay, so thank you so much for these presentations. I want to ask Roy, so Roy, you were talking about the utopia and the structural reform that is needed in order to, save the world from GVCs and more.
I didn't say the word utopia.
Yeah, you didn't. And then at the and you describe the works of Jaako and others that are trying to reform that, like the private law from within, and you say this is very important works, etc., etc. But I want to understand if this is paying a lip service, or are you serious about that? Because doesn't these kind of little corrections within private law crowding out the ability to reform the system in a bigger way? So, and I think that's what you hint at the beginning, right? Trying to do that from within is problematic because, what we do is, just, changing, taking a brick, moving it from side to side, and it's actually preventing from the bigger structural kind of reform from happening.
So no, I don't think reform is what will prevent uh, I don't think reform from within is what will prevent, um, something else from happening. But part of that, so, you know, one of the really intriguing things about, the breadth with which Jaako comes to this project is, the opening about we have so many tools, we should imagine ourselves as knowing all the consequences of our actions and so on. Now, that's,
It's not an imaginary, it's the reality right now.
well,
Sorry.
anyway, I think it's fascinating and it's necessary as something to think about. And at the same time, I think the places where people rely on the fact that our tools are so well developed that we know the consequences of our actions are, um, typically disastrously, sometimes humorously, sometimes, but often monstrously wrong. One of the things about there being humans is that we don't know consequences, but and what the one thing I feel pretty confident about is that my work as a contract theorist is not going to make a difference in the structural shape of capitalism. What I can do as a contract theorist is to, in ways that whose consequences I will never be able to imagine, is I can help people, the few people who read me, maybe some of my students, to think about the world in slightly different ways. And so one of the things that I would encourage them to do is to get on board projects that they feel committed about. Some of those projects will make the world even slightly better right away. And that's hugely important work. And I totally support it. Another thing that I will do when I try to, say something or teach or write is to shake the confidence regarding how well we've done. And so, here's a little story. Medical malpractice looks in the United States like a system with tons and tons of accountability, and an entire industry of insurance has been refining the ways that doctors should behave but what does it do? It aligns, for the profit of the insurance companies, it aligns behavior with their risk management strategy rather than with the social goal of improving medical outcomes. And so the United States has the worst medical outcomes because of the ways that defensive medicine is practiced for insurance companies. Whereas there's another ethic of what to do about medical malpractice, which is an internal medical ethic, which tends to do a little better. Now, maybe insurance companies will eventually, with the right tools, they'll get it right. And the accountability paradigm, taken to its extreme, will actually make things better. So far, not the case. Okay. So I tend to think about those things and to think about the ways that the profit motive isn't aligned with social benefit, but rather distortive of social benefit, and to point them out because I think they're important. And I think that the general story, the way that many people think, okay, the basic situation would be good except for market failures, right? I think that story is wrong and dangerous. Now, but that completely doesn't mean that for making things better on the ground in the day-to-day of, right now, there are a million things that we could do. It's hugely important. It's not lip service. So, and, you can take that right to our terrible political situation today. People who make a difference for other people's lives today are really making a difference. And the fact that that isn't about the revolution for tomorrow doesn't take away really, for me, it doesn't take anything away from that.
I would sort of want to say that I perfectly agree, and much of this work on GVCs, for me at least, is fundamental in highlighting the things we can do with contract. And there are so many horrible examples of what we can do. And the example that's now a classic for me is, well, the Finnish military creating these new kinds of contracts with the Israeli defense industry about supplying advanced air defense missiles under all states of exception. And they have a contract clause there. Rafael promises to send rockets over under all states of exception. And one starts wondering what kind of a global value chain reality underlies these contract clauses and how they can be enforced, not enforced in the traditional sense, but enforced in other ways, how contracts give us the means to see what's going on in different areas of the world, to make these very accurate maps about what kind of states of exception can arise in this horrible global political economy, and then create contractual mechanisms or enable mechanisms that maybe probably from a traditional contractual perspective are totally outside the contract to ensure that these missiles then come from Israel all the way to Finland in all kinds of nasty situations that one can imagine right now. So it's a lot about that.
Should take two more comments and then you kind of integrate into that, and you'll.
I'm just trying to say that then if we try to be a bit more utopistic, we need to think beyond this. And I'm still wondering, I mean, such a focus on capitalism instead of humans and the system, and the whole point with tort being that damage caused must be remedied, it sort of floats further away from these nastinesses perhaps than contract. So I would like to steer the discussion a bit that word, but sure, comments.
We'll get back to you. Yaniv.
Thank you. So first of all, this is really fascinating, and thank you for the papers and for this opportunity. And I have one question for each of the presenters, if it's okay, to pose two questions. But I would like first to say something as a comment about what I saw as an interesting meeting point between the two papers, and that is the product liability paradigm that both of you described, and in some ways criticizing, but in different ways criticizing it. But the comment is just to remind, as someone who studied different processes of the history of product liability, that it didn't just come from the law. It took a lot of political struggle from non-legal actors and collective actors to get to the product liability paradigm that exists, and this was domestically. So I don't know, maybe I offer another criticisms of the product liability that, you know, it takes a lot of political struggles to get there, and I'm not sure that on the trans or national or global scale there are you know, these actors. But now for the questions. So first of all, to Roy's paper, really a fascinating paper and a very, very interesting one. The invocation of Veblen led me to think or question, is contract theory, or I don't know, maybe to ask for your comment about thinking about corporate theory and how that might be relevant for governance and, you know, corporate theory. Well, I don't know, maybe this is, you know, you're an expert on contract theory, but surely more an expert than I am on corporate theory as well. But the web of contracts is not the only way to theorize corporations. And, you know, so other theories might be helpful here. And so I would just like to hear your thoughts about, you know, the interaction between contract theory and corporate theory. And to Jaako, I must admit that my engagement with the paper was less on the deep level than with Roy's paper. But so you know, forgive me if this is kind of like an, I don't know, unfair question, but reading your paper, I was just thinking whether this paper might be read as a manual actually for GVCs or for corporations to shed their liability towards human instead of the other way around. I think that sometimes is you know, something So that happens a lot with utopians or papers that try to pave the way to utopia. They can also be read as a manual for dystopia. I'm sure that this is not what you intended, but do you think it can be read that way? Your suggestion or your proposal. These are my questions.
Thanks, Yaniv. Klaas, so I want to hop in.
Yeah, thanks. So what I think both of your presentations, and thanks, this was a really nice dialogue, made me think about is that in a way you both presented a relatively fundamental challenge to a project like the law of GVCs. So if we think historically of where the focus on GVCs came from, it was this kind of liberating idea that, well, we have to look beyond individual entities, we have to look transnationally, we have to follow the flow of business decisions and material and actual economic impacts around the world. And that was the basis of the UN guiding principles. And a lot of the regulatory discourse, I think, is still based on the idea that by bringing in more GVC conceptuality, we're potentially expanding liability, we're getting closer to economic power, etc. So GVCs were this meso-level framework through which we could address the global economy. It was a way to make things more tangible and the critical twist then that I take from both of your presentations was in a way to say, well, maybe we've come to a moment where the GVC concept actually backfires in the sense that we see with the omnibus, the definition of a GVC is being limited down, the intensity of GVC-related obligations is shrinking, and we're obscuring in a way the big path not taken, which would be structural reform and actually talking about markets again rather than GVCs. So to what extent are we at this critical juncture where the GVC as a legal concept and the many ways it's being taken up in regulatory terms is not only no longer fulfilling its initial aspiration, but actually almost serves as a liability shielding and kind of imaginary limiting device.
I would like to add perhaps one question is on what's the relationship between these two articles and the first discussion we had in antitrust and labor law, where there are also contracts there. And I think that the main thing that we think about contract in this discussion is about the contractual relations between the nodes along the global value chain and the way that they reshape our conception of the corporation. And I wonder, is there a different story here than the story of all the others surrounding them, whether it's other global value chains that may cooperate on extending living wage arrangements around the globe in cooperation, or about cooperation between workers in different nodes and maybe workers in the same municipality but with different global value chains. So is there a rethinking here of contract law, or is there or of contract, or is this a rethinking that is particular to the vertical view of the global value chain? Who wants to start?
Doesn't matter.
It can be one of negotiate.
Why don't you
negotiate a contract between you? I don't know. Yeah.
Yeah, well, that's a very interesting contract we have between me and Roy.
Yeah.
Write a paper
And
about that.
you each have about 4 minutes. Yeah.
Well, I don't even know where to start. I'd like to start with what Roy was trying to end up with this positive note about telling students and what the right thing is. And I think this is sort of very... It's a lot about something much bigger than contract law. It's about understanding the global consequences of our lives. And there is this debate. And this debate is filtering into even basic contract manuals in Sweden, in the sense that the first year contract students that I have, they read a book where an old Supreme Court justice tries to figure out whether the new consumer sales code is somehow trying to somehow makes it easier to create a circular economy or not. And he is very critical of the new consumer sales code from this perspective, thinking about its global consequences, what these basic contractual doctrines have for global consequences. So it's a lot about this, trying to highlight that there is this reality that contract lawyers don't usually take for granted when they look at the contracts, that we should integrate these thoughts about the reality of global value chains into contractual discussions. And then, of course, they can be used for the good or for the bad. Coming back to, sorry, was it Yaniv's question? I mean, 2018, 2016, I wrote a paper arguing that the Bangladesh Accord could be construed as a liability limiting device. And of course, at that point, most traditional contract lawyers or tort lawyers would have said that there's no liability that you're trying to limit because it's such a crazy thing. But I guess that goes without saying that I've been cognizant of that, and even before, well, I mean, we still don't. It's very dubious whether that kind of a liability for a Rana Plaza kind of a disaster could exist. Well, yeah, I wrote a paper almost 10 years ago arguing that it's just a liability limiting device, this wonderful contract that saves the world or saves the laborers of Bangladesh. The word's out on what the reality is. What is going on here? I really feel that we should. Now I sort of think I sort of lost myself. Rethinking contract law, definitely. GVCs today can be used for
You have
good and
about
bad.
2
The
minutes,
whole,
so choose,
yeah, I know.
choose the one main point you want to address.
The one main point, and I guess the one main point is
minutes.
that because of the problems of contract, then I've been thinking about these theories of tort and the basic idea that damage caused must be remedied, corrective justice. And if we know that we cause damage in doing something, then shouldn't we remedy that justice? Of course, there are even more problems with tort law than there are with trying to recreate a more fair doctrine of contracts. I mean, I still haven't gotten into American Second World War tort doctrine on these points, but I mean, I'll get there eventually. But I sort of see that this discussion transcends discussions of global trade. This transcends discussions of global capitalism. We've had some kind of an idea of corrective justice for thousands of years, if not more. And I guess that would be then the next place to put the GVC discussion in much more debate, much more focus there. There's something that I was thinking about. Yeah, the global political economy right now. I don't really see that as a bad backlash either, because, well, the more we end up in this fragmented world where we have a certain new kind of a Cold War between, I don't know, if you want to name the United States, Europe, China, Russia, whatever actors, I mean, the more there is also a need to use different kinds of techniques of cooperation, stakeholder activism to pursue goals, not necessarily for global sustainability, even though at some critical tipping point of the world, probably for that also, but for securing the critical materials from other places. So our knowledge of what we can do in contract, global value chains through contract or through tort or through whatever legal doctrines, through market building, through reconceptualizing the market is increasing. And we will be using this knowledge for securing interests that either can be for the global good or can be then for the local good, local policy objectives. But even when we use these techniques for securing local policy objectives, like the survival of the European Union because of rare earth, we're at the same time creating this very irritating problem. If we can do these things, if we can get those missiles from Israel, despite, I mean, I don't know, war going on there, why can't we use these same things for more positive things also? And this is then a more philosophical debate or political debate that we will be facing. And for me, at least, the point of all this is to highlight the possibilities that companies, that private individuals have in affecting the world system, and to put this debate, put these legal techniques of governance, of control that you and me can utilize on the table. And the sad point is that, of course, we can imagine a world where we just decide that maybe slavery was good in the Roman Empire and we need to have neocolonialism, but at least we can't shy away and hide this debate behind legal doctrines anymore. It's on the table. The cat is on the table, and we need to decide what kind of a life we want to live. So for me, that would
we'll
be
stop
the
here, Jaako.
ultimate.
I want to leave 5
point.
minutes for Roy.
Yeah. So, you know, I think one of the sort of, inspiring but difficult things that comes out of Jaako's take on this is that when we think about responsibility for the consequences that we can know, it runs the entire gamut from, well, we should regulate corporations because they know the consequences of their actions, but all the way down to the individual, and it's humbling, and it's, to think about how complicit as we are in all kinds of terrible things is, I think it's a deep point and one that we can't ignore. So I think it's the right way to think, although it makes me sad. So Yaniv, on contract theory and corporate theory. So I think one of the nexus of contracts as a corporate theory is definitely not the only theory out there, and it's not totally in favor. I think one of the interesting thing to try to get at is that if we're doing corporate theory seriously, what we're trying to take into account is that there's a tension between imagining the corporation as a little feudal unit where the mode of authority is not contract. And that is one model of the corporation. And then corporations act in a certain way. They have, people have authority in corporations in a way that isn't contractual. And it may be built on logics that we approve of or that we disapprove of, right? So we have hierarchies through contracts, the way we've been analyzing them in GVCs. We have hierarchies in other corporate bodies that work on different logics. So I think we could think about different kinds of logics that work in contractual settings in the way that we, right? So if I say a corporate world, right? The church is a corporation, and there we're not confused about the hierarchies and the system of authority not being contractual. And we think it has a logic that has things that we may think are very valuable, things that we may think are bad. The same thing we can try to think about contractually. One of the things that motivated contract becoming such a major trope for modernization was that it practically disintegrated those other modes of authority. It made all authority into something impersonal, which was actually no longer authority. It was just contractual binding that was supposedly with all the parts known, and based on consent. And so it didn't actually work like that in practice, but that's what it did to our thinking about authority. So I think, one of the things we can do in a mode of thinking about where to go is thinking about where we want other modes of authority and other logics to be, to be dominant or to be protected, as opposed to the modes of authority which are just profit seeking. And I don't know if thinking in that way, and this goes to Klaas's point, will help us or will hinder us from doing the work of social engineering that is thinking about, the global economy or the global or, global structures, if you want to take them even beyond the economy, to the sort of to the places where Jaako was starting with, the entire sustainability of the earth, which is not only an economic question, right? So I really don't know which way of, if trying to resurrect the place of other logics, for instance, and to give other modes of authority some kind of protection vis-a-vis, you know, I don't know, contractual in the basic sense, modes of authority. is going to be a good thing or a bad thing. I think we should play with the thought to figure out what we think about that. My predilections are pluralistic, and I think one of the things that's happened over the years is that contract has become such a dominant way of thinking that it limits our other imaginations. So I think, we're in an age of tyranny of contract. And so that is my worry. Guy, we'll have to talk later because we've run out of time.
Yeah, we have. And we're gonna take 20 minutes now for a break. And I'd really like to thank both of you for your thoughts, for your engagement.
And I'd in particular like to thank Jaako because I felt like he was my teacher into the GVC literature because I got to read a lot of his stuff and it was really an enriching experience. So thank you for that.
Cool.
Thank you, Roy. I wanted to talk so much more about everything you wrote with you, but I guess we'll have a chance later on. So
You will have. And
I've
again,
jotted a
we'll
few
open
notes
up
about
another
that.
line in Oniati, and we'll continue private law with Anna in class after the break. Okay.